when you appeal, one of the things that you need to do is brief the court. You have to remember that the court doesn't know where you're coming from. The court isn't familiar with the lower court's case yet. So you want your brief to get the court's attention. This brief gets the court's attention in all of the wrong ways. Indeed, the appeal is utterly frivolous, and McCurry's monstrosity of an appellant brief is incoherent. So we also order her lawyer to show cause why he should not be sanctioned or otherwise disciplined under Rules 28 and 38 of the Federal Rules of Appellate Procedure.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
The United States Court of Appeals for the Seventh Circuit, in the case of Edith McMurray and Kenco Logistics, has had to do a lot of sort of piecing together of the case. And in the process, they expressed their displeasure at the quality of the appellant, in this case, Edith McCurry's brief. This brief gets the court's attention in all of the wrong ways. And we're going to go over the Seventh Circuit Appeals Court's decision, which is 16 pages long, but it's those little short pages, so it should go fairly quickly. And then I have dessert for you. I promise you it will be worth it. I have the appeals court brief. I have the appellate brief, and I think you will really enjoy going through that as well and seeing what is it that was wrong with it. Is it really that terrible, or is the appeals court just being picky? So let's get started. All right, everyone, this is Edith McCurry versus Kenco Logistics. Edith McCurry worked at an Illinois warehouse owned by Mars, the well-known candy maker, and operated by Kenco Logistics Services, a third-party management firm. In March 2015, Kenco lost its contract with Mars and laid off its employees at the warehouse, including McCurry. More than a year later, she filed 2 rambling, pro se complaints accusing Kenco, Mars, and several of her supervisors of discriminating against her based on her protected class. She also alleged that Kenco and Mars conspired to violate her civil rights. The district court consolidated the suits and dismissed some of the claims. The defendants then moved for summary judgment. McCurry's response violated the local summary judgment rule, so the judge accepted the defendants' factual submissions as admitted and entered judgment in their favor. McCurry retained counsel and appealed. We affirm McCurry doesn't challenge the judge's decision to enforce the local summary judgment rule. As a result, and unsurprisingly, the uncontested record contains no evidence to support a viable discrimination or conspiracy claim. Indeed, the appeal is utterly frivolous, and McCurry's monstrosity of an appellant brief is incoherent. So we also order her lawyer, Jordan Hoffman, to show cause why he should not be sanctioned or otherwise disciplined under Rules 28 and 38 of the Federal Rules of Appellate Procedure. We begin with the judge's decision to enforce Local Rule 71D, which governs the summary judgment process. McCurry violated multiple provisions of the rule. We include a sampling to provide an understanding of her noncompliance. Under one rule, a response to summary judgment motion must include the following specific sections: an introduction, a response to the moving party's statement of undisputed material facts, an argument section. McCurry's response to defendants' motions contained none of those sections. It was instead a disorganized, rambling, hard-to-decipher mess. Another rule requires that the response to the moving party's statement of material facts identify in separate subsections: 1, the undisputed facts; 2, the disputed facts; 3, the immaterial facts that are disputed; 4, and the immaterial facts that are undisputed; and 5, any additional material facts. Remember, summary judgment is all about getting undisputed and disputed facts and figuring out what you have to actually go to trial on. And if there's anything left to go to trial on that needs a fact finder, like a judge in a bench trial or a jury in a jury trial, if there's anything left for the fact finder and it's a material fact, then you don't grant summary judgment as to that issue and you go to trial on that issue. Each disputed fact conceded to be material must be listed, etc. McCurry's response was woefully non-compliant with these requirements. She responded to some facts by number, but said only that she objected to them. She did not state the basis for her objections, nor did she respond with appropriate and specific citations to evidentiary documentation. Although McCurry did not include an argument section in her brief at all, her arguments were scattered randomly throughout her 62-page response, in probable violation of another rule which limits the argument section to 15 pages or 7,000 words. Under another rule, the failure to properly respond to a numbered fact with an opponent's statement of facts will be deemed an admission. So if you don't properly deny an opponent's statement, then you admit it. So you better do that properly. In light of her widespread noncompliance, the judge deemed the factual submissions admitted against her. As we've noted, McCurry doesn't challenge the judge's decision to enforce the rules. Even if she had, we have repeatedly held that district judges may strictly enforce local summary judgment rules, and the judge reasonably did so here. Accordingly, our account of the facts is drawn from the defendant's uncontested factual submissions. So, I don't know if this is going to make it into the final production, but we're going to take a few minutes and go over what actually happened to see if it's interesting or not. I did read it. It's kind of interesting, and you're going to learn a little bit about a piece of law that we don't often go over, this kind of employment dispute. We begin in 2013 when Mars contracted with Kenco Logistics, a third-party logistics firm, to manage its warehouse in Illinois. Under the parties' agreement, Kenco was responsible for day-to-day operations and exercised full control over its own employment policies. Kenco retained several employees from the previous warehouse manager. One holdover was Edith McCurry, who worked in human resources. McCurry, a black woman born in 1962, performed clerical and administrative duties such as handling warehouse payroll, generating reports, and assisting with employee relations. She had no managerial responsibilities. In October 2014, Kenco hired Lori Varvel, a white woman 17 years younger than McCurry, as the human resources manager. Varvel assumed some of McCurry's duties, though McCurry's pay remained the same. On December 9th, McCurry worked an hour and a half of unauthorized overtime in violation of Kenco's timekeeping policy. 10 days later, Varvel gave her a written warning for working overtime without authorization, misrepresenting her hours, and failing to report the correct hours. On January 29, 2015, Kenco announced that it had lost the Mars contract and that all employees at the warehouse would be let go at the end of March. In August 2016, McCurry filed a 77-page, 386-paragraph pro se complaint against Kenco, Mars, and several supervisors alleging discrimination based on her protected classes. She also alleged a claim for conspiracy to violate her civil rights and several state law claims. None of her claims alleged that she was fired for a discriminatory reason. Rather, she complained about conduct during the course of her employment at the Mars warehouse. Not 2 weeks later, McCurry filed a second lawsuit against largely the same group of defendants. This one, like the first, was sprawling. A second lawsuit, 89 pages, and another 423 paragraphs, was more rambling than the first, but more or less repeated the allegations of the previous suit. The district court consolidated the cases. The judge dismissed some claims, but allowed the following claims to proceed. Claims against Kenco for discrimination on the basis of race and sex in violation of Title VII, and 2, a claim against Ken Komars and the supervisors for discrimination on the basis of race in violation of 42 U.S.C. 1981. 3, a claim against Kenco for violation of the Age Discrimination in Employment Act. And 4, a claim against Kenco for violation of the Americans with Disabilities Act. And 5, a conspiracy claim against Ken Komars and the supervisors under 42 U.S.C. 1985. The defendants moved for summary judgment on these surviving claims. As we've explained, McCurry's response did not comply with the local rules, so the judge accepted the defendant's statement of facts as admitted. Charitably, working his way through each claim, the judge concluded that the evidence was insufficient to support liability for any form of employment discrimination or conspiracy. McCurry moved for reconsideration. The judge denied, noting that McCurry did not identify any newly discovered evidence and merely rehashed old arguments. The judge also elaborated on his decision, providing an exhaustive account of McCurry's violations. We review de novo, which means brand new. Summary judgment is warranted if the party shows that there is no genuine issue as to any material fact and he is entitled to judgment as a matter of the operation of law. And that's why we keep seeing material facts and disputed versus undisputed material facts, because we really care about disputed material facts. As this case comes to us, the record is limited to the defendant's evidentiary submissions, so no additional evidence is coming in. This is on the record as it exists. They're going to look at the record as it exists. So as to the legal analysis for discrimination, the analysis is the same for Title VII and Section 1981. The court merges those two claims and then asks about any discrimination case. We ask whether the evidence would permit a reasonable fact finder to conclude that the employee was subject to an adverse employment action based on a statutorily prohibited factor, here, race or sex. McCurry maintains that they discriminated against her by paying her less than her white male coworker, Leonard Splett. I'm so sorry, Mr. Splett. I'm sure that you've received lots of bullying for your name in the past, and I don't mean to pile on, but that is a funny name. Splett earned more than McCurry because he had extensive managerial responsibilities and she had none. McCurry's unequal pay claim is therefore baseless. Next, McCurry argues that Kenco discriminated against her by hiring Varvel as these names, people with these names, as the human resources manager. This is essentially a failure to promote claim, so McCurry must show, 1, she was the member. I can't get over it. That's a really funny name. I just need to get it out. So let me get it out for a second. This is essentially a failure to promote claim, so McCurry must show, 1, she was a member of a protected class, 2, she was qualified for the position she sought, 3, she was rejected for the position, and 4, the employer promoted someone outside of the protected class who wasn't better qualified. McCurry did not apply for the position of human resources manager, so her failure to promote claim does not meet requirements 2 and 3. This claim, 2, is baseless. Relatedly, she contends that the reduction of her job duties after Varvel was hired was discriminatory. This is yet another baseless claim. Inconveniences and modest alterations of job responsibilities are not adverse employment actions, and the decision to have Varvel handle employee relations matters had nothing to do with her race or gender. Rather, Varvel had prior management experience at a large corporation and assumed these responsibilities because she was far more qualified than McCurry. So then they go into the ADEA, which prohibits an employer from refusing to hire a person who is 40 or older because of age. Her age discrimination claim is based on their decision to hire Varvel as the human resources manager. McCurry was 52 and Varvel was 17 years younger. We have already explained that McCurry did not apply for this job and that Varvel was hired because she was far more qualified. There is no evidence to support an age discrimination claim. The Americans with Disabilities Act prohibits an employer from discriminating against a qualified person on the basis of disability. McCurry argues that Kenco violated the ADA when her COBRA health insurance costs changed after the layoff and she did not receive COBRA open enrollment paperwork. It's not clear how problems with COBRA health insurance can be an ADA violation. Regardless, the judge granted summary judgment for Kenko because a third-party administrator was responsible for the laid-off employees' COBRA-related benefits. McCurry did not challenge this ruling or even mention it in her opening brief on appeal, raising it only in her reply brief. That's a waiver, says the court. That's a waiver. Just nonchalantly, the court is like, I'm done with this. That's a waiver. All right, so next we're going to get to the fun part. So this is the part we've been waiting for. If you are not listening because that's all boring stuff to you, and it kind of is, but it's also really interesting to see how do employment discrimination claims work. That was literally what, like a 10-minute summary. That you have all of that employment discrimination knowledge just compacted right there into 10 minutes. But let's get to the fun part. Let's eat dessert. This appeal represents a shameful waste of judicial resources. We take this opportunity to reiterate that district judges may require strict compliance with local summary judgment rules. The rules exist to ensure the fair and expeditious resolution of legal controversies and are well tailored to bring order and intelligibility to the summary judgment process. Litigants and attorneys may chafe under the rules from time to time, but the kind of organization the rules require must occur sooner or later, and the system as a whole is better served if it happens sooner. Moreover, the purpose of an appeal is to evaluate the reasoning and result reached by the district court. The rules of appellate procedure are designed to make appellate briefs as valuable an aid to the decisional process as they can be. Non-compliance with appellate rules wastes time and resources and frustrates the review process. Sanctions are appropriate when the rules are violated, especially when the violations are multiple and flagrant, as they are here. Rule 38 to the Federal Rules of Appellate Procedure. When's the last time we talked about the Federal Rules of Appellate Procedure? Come on, you're learning something really cool here. Permits us to impose sanctions if an appeal is frivolous. If a court of appeals determines that an appeal is frivolous, it may, after a separately filed motion or notice from the court and reasonable opportunity to respond, award just damages and single or double costs to the appellee. An appeal is frivolous if the appellant's claims are cursory, totally undeveloped, or reassert a previously rejected version of the facts. An appeal is also frivolous if it presents arguments that are so insubstantial that they are guaranteed to lose. McCurry's appeal rests on factual assertions that were excluded from consideration below because McCurry disregarded several provisions in the local summary judgment rule. As we've explained, there is no basis to disturb that ruling, even if McCurry had challenged it, which she did not. Her appellate arguments are insubstantial to the point of incoherence and had no chance of prevailing in this court. The result has been the harassment of opposing parties, insult to judicial officers, and waste of limited and valuable judicial resources. The patently frivolous nature of this appeal isn't the only thing that troubles us. The hopelessness of McCurry's cause didn't deter her lawyer, Jordan Hoffman, from signing and submitting a bizarre appellate brief laden with assertions that have no basis in the record and arguments that have no basis in the law. In doing so, Hoffman violated Rule 28 of the Federal Rules of Appellate Procedure, which require a concise statement of the case that sets out the facts relevant to the issues submitted for review, and a summary of the argument containing a succinct, clear, and accurate statement of the arguments made in the body of the brief. McCurry's brief, which spans 86 interminable pages, is neither concise nor clear. It is chock full of impenetrable arguments and unsupported assertions, and it is organized in ways that escape our understanding. There's 2 footnotes here. Footnote 4 says, he signed the brief on behalf of, quote, plaintiff appellant Mary Madison, end quote, who is not a party in this case. This is yet another way in which the brief is out of the ordinary. And then they quote the term brief as a definition Deriving from the Latin brevis, meaning short, the term brief seems inapt here, they say. It is a typographical nightmare. It uses 5 different fonts and various font sizes, including 3 different fonts in one sentence, and capitalizes words seemingly at random. Here is a representative sample of assertions organized in ways that escape the court's understanding. McCurry's brief seeks review of a variety of interlocutory orders without specifying why the orders were deficient. Interlocutory means orders that came through in the middle of litigation. These orders included the amended complaint, which is not an order, multiple waivers of service, which are not orders, and a routine protective order, hey, an order, allowing the parties to mark discovery documents as confidential. Well, that's not really, that's like a consent order. That's not quite the same thing. A consent order like that would totally routine. The brief accuses the defendants of criminal obstruction of justice in a footnote, and in a footnote asserts that defendants' schemes were furthered by the U.S. mail. When we questioned Hoffman about this outrageous accusation at oral argument, he apologized. He then opined that civil obstruction, if anything, took place. There is no cause of action for civil obstruction of justice. I mean that literally. There is no civil cause of action. You cannot sue someone for obstruction of justice. You have civil remedies in court if someone is obstructing justice in your case. You can say that to the judge in a motion for sanctions, a motion for a motion to compel production of documents or to compel testimony. The brief invokes res judicata, collateral estoppel, and judicial estoppel, none of which apply, none of which were asserted below, and all of which are therefore waived. The brief includes a section entitled Gamesmanship, which contains the following assertion: defendants have been gaming the system. There is nothing else in the gamesmanship section. The brief contains many sentences like this one, all errors in original. In other words, the court is repeating the errors as they were written. McCurry experiences a change in fringe benefits, harsher scrutiny, failure to be promoted, lack of opportunities, lack of professional standing, economic sanctions, hostile work environment that led to an employee being shot on the premise, various verbal and physical assaults of African Americans by Caucasian employees of use of gun violence, vehicular assault, amongst other forms of violence, the ever-looming threat that a racially motivated altercation or riot may ensue, and physical damage to McCurry's auto, amongst actions/activities/conduct.
Okay, I'm sorry. There's so much there. Okay. Wow. Oh, wow. Okay. Oh my God. And okay.
We haven't even gotten to the real thing yet. This is the summary we're reading.
I know. And I also have to go back to how the court said that this writing is so bad that it's actually harassment. And so it's not just like this is bad and you should feel bad, but it's this is bad, you should feel bad. And furthermore, you should feel bad about how bad other people feel reading your badness. Like there are layers here.
OPT lawyer exclaims, "This was filed," and I'm trying to contain this was filed by an attorney. This was filed by a licensed attorney.
Yeah, I understand that courts are mandated to give pro se litigants extra leeway and room. They are not mandated to be nice to lawyers.
Yeah, I would have chosen to not ghostwrite because you're not allowed to ghostwrite. That's a little known thing. Lawyers are not allowed to write your brief for you and then you turn it in as a pro se litigant. The court wants the author to be accountable to what they've written, especially when that author is a licensed attorney, an officer of the court can't hide behind that pro se litigant's privilege of being a pro se litigant. I hate it a little bit. Hate's a strong word. I'm being dramatic. I like being dramatic a little bit, but I don't like it a little bit because I feel like I'm being held to a much higher standard than the pro se, than the lowly pro se is, the lowly untrained pro se. And sure, I don't think I should get as much leeway as a pro se, but I feel like it's complete opposite ends of the bell curve here, and I'd much rather like be in the middle of the bell curve, and the pro se gets a little bit of leeway, maybe not as much, or maybe I'm not held to as high a standard. Like minor mistakes should be able to be corrected. Leibowitz, for example, if he had eaten crow immediately and said, yeah, Judge, I'm sorry, nobody died. He didn't even lie to the court. Like if he just immediately said, I just missed the court date because I'm dumb, whatever, he'd probably cite excusable neglect or something like that. And yes, Your Honor, I understand I'm going to pay for the cost of missing the hearing. I'm really sorry. That a lot less would be happening to him, probably almost nothing.
But I feel with the ghostwriting that this is like the opposite of that, where instead of the lawyer writing something and the pro se turning it in, the pro se has written it and the lawyer is turning it in and be like, dude, no. No.
Yeah.
You are going to be held to lawyer standards.
There is more, but the point is made. Bad writing does not normally warrant sanctions, but we draw the line at gibberish. We sometimes invoke Rule 28 when the briefing is too abbreviated and sketchy to facilitate review, but there is no functional difference between a scanty brief and an overly long, borderline unintelligible brief. Both require us to supply the legal research and organization to make sense of the parties' arguments. In both cases, we are frustrated in performing our review function and in evaluating the judgment below. Although we disregard McCurry's factual assertions because they are unsupported, we conclude with an observation about their substance. McCurry's brief asserts, among other things, that Kenko and Mars fostered a workplace environment where racist acts, including the attempted murder by forklift of an African-American employee, went unpunished. It asserts that consumers of Mars products could have been affected by food products contaminated by vermin and their leavings, and it asserts that Kenko's management engaged in various forms of psychological warfare by contriving scenarios in which African Americans were publicly reprimanded and falsely accused of smelling like drugs. These baseless assertions are shockingly irresponsible. Because we have a duty to maintain public confidence in the legal profession and protect the integrity of the judicial proceeding, we confronted Hoffman about his brief at oral argument. He replied that he is a solo practitioner who tries to get the help of clients and whoever can provide help to him, and then merges that information. Whatever that means, it in no way excuses this unprofessional conduct. Hoffman's filings fall far below the reasonable standards of practice. We therefore order him to show cause within 14 days, I think this is November 6th is when this came down, why he should not be sanctioned or otherwise disciplined under the federal rules of appellate procedure. We also direct the clerk of this court to send a copy of this opinion to the Illinois Attorney Registration and Disciplinary Commission for any action it deems appropriate, and the court affirms the lower court's judgment. So what do you think of that? That is incompetence. That is Rule 1-1 incompetence. You should not be representing clients if you can't do a proper job of it. I literally would not take, and I literally this week told somebody that I would not be prepared to take their case to appeal. Not that their case is over, but rather I'm going to go find them another lawyer. I'm not going to go charge them for the time it takes me to help find a lawyer. I'm going to help find them a competent lawyer, one that I would feel responsible for if it went wrong or right. And I'm going to recommend a lawyer. And if I can't find somebody, I'm going to explain to my client why I can or can't find somebody. In other words, the client is going to be fully informed about the entire situation and not led on some hopeless expedition to get the lawyer fees and maybe get the appeals court to say one paragraph of nasty things that doesn't otherwise affect the case. So the court said there's something here, but neither the lawyer did their diligence, nor did the client hire a lawyer or provide the amount of resources that would be able to sustain this kind of case. That's harsh. That second part is harsh. That's an access to justice issue. Should a person who's facing unemployment have to spend the money they don't have on a lawyer and a case and an investigation, and they have to go against an employer who has nearly unlimited resources compared to the limited resources of the now unemployed former employee? So it is an access to justice issue. And you see what can happen now. I feel very badly for Edith McCurry, who seems to have some kind of a case, but can't get it adjudicated because of the, I'm going to use the word technically, the incompetence of her representation. Again, Rule 1.1 duty of competence. You don't take cases, you don't lead clients on hopeless expeditions when you can't do something, you can't take a case. Clients call me with patent questions all the time. I sometimes will consult, but only where I have something to offer. I usually offer some kind of money back or satisfaction guarantee. There's also some kind of satisfaction guarantee built into the rules of professional conduct. If there's a fee dispute, it usually goes in favor of the client. So why would you ever take these things on if you're not prepared? Well, let's take a look at what actually got filed. We can disregard this part. This is not because of Edith McCurry or her attorney. The rest of it is, though. So this is the appellant's brief, and we're just going to page through this. I'm not reading this, but you can see here we've got some bold and caps and stuff, and that's fine. It looks like a fine caption so far. And then you've got this, this caption here, and here's his address and everything. It's the office address. It's not a personal address. Here we have some interesting things going on here. We're in a different font now. And these things are not lined up. Like if I draw a line with my thing here, we are really not lined up here. So that's weird. Then we've got cases, a table of cases, and these page numbers. This is hard to find. Like you want the page numbers lined up on the right side, and with a little bit of effort, very little effort, but with like just looking up how to do it, Microsoft Word and almost any word processor does all this for you. If you use your styles properly, you can then generate a table of contents from your styles. Your styles would be your headings, so like heading 1, 2, 3, 4, 5, and then like, body type 1, body type 2, body type list, body type bullets, whatever. And then those can then be inserted into a table of contents hierarchy, and then you click OK, and suddenly you've got a table of contents page. Look it up. There's no excuse for that, really. Not from a professional. This is a person who is a professional writer. So this shouldn't be this incoherent. It's good that it's here, but this shouldn't be this incoherent. So here we have randomly bolded text, but okay, we're still in some kind of like statute or regulation. But once again, it's not justified. Literally, the text is not, it's left justified, right justified. This is like justified. Like it should be, the page numbers should be all the way over here and all lined up and everything nicely. Oh, okay, so here we go. Here is some text. I'm going to back out a little bit so you can get kind of a look at it. Here we have two different fonts, I think. I think these are two different fonts here. These are definitely two different fonts. Here's weird spacing. So he's forgotten about the extra 12-point spacing there. Again, this is the lack of the use of styles. Here we have a different font for statement of the case and for the heading. The different font, whatever font they've chosen here makes it hard to read. Again, look up what fonts you should be using for making things easy to read, making things pleasant to read. Some fonts are very stylistic and look very nice, but I wouldn't want to read an entire book in the Death Stranding font. Even though it's a normal sans serif font, it's just an ugly font for reading. It's a cool font for making the point of the style of Death Stranding.
As a former TA, I'm getting so triggered by this. I'm just like,
oh,
I want to like just mark this up with red all of the time.
This is someone who has not considered their audience. So have any of you guys ever gone through life and maybe run into a person, or maybe you've even been the person? I mean, I've certainly been the person once or twice in my life, maybe even for a good portion of my life, didn't understand other people's points of view. I for a long time did not understand, and I'm talking about as like an immature child. I mean, like as growing up into a child, and then I'll fully admit it here. I have a little bit of an emotional developmental delay, so I was well into my 20s before I was fully emotionally developed, and it was hard for me to see things from other people's points of view. I certainly had some kind of emotional empathy, very strong emotional empathy, but didn't quite understand that other people could have the same amount of information that I did and not come to the same conclusion, let alone that other people might not perceive or understand or incorporate the same amount of information that I did. So they might come to a wildly different conclusion based on a completely different perception of the same events, or just simply that people have different perspectives. These were all concepts that I had to come to. Where am I going with this? Audience. You have an audience that you need to write to. We're constantly working on how to engage with you, our audience, breaking the fourth wall a little bit here. So here, Attorney Hoffman has failed to remember he's writing to an appellate court, and that court is going to be distracted by this statement of facts being in a different font and broken off from this. And okay, footnote doesn't look too terribly bad. There's a mixture of sans serif fonts and serif fonts. What's that? A sans serif font doesn't have those little squiggles at the end of the thing, those little flourishes at the end of the edges and angles of the fonts. A serif font has that. And there's also other categorizations of fonts, but we generally don't switch between them because it looks super weird. So that's what he's doing here. Look, summary of judgment has a different bold than standard of review. What? Factual background is italicized. Okay, why? What? There's strange space between paragraphs. Yes, I know Word does that, but Word is not, you don't just default style on Word. This is not italicized. Argument is not italicized, but it's bolded. Like, do I even want to look at what he's written? I'm so put off by the formatting that now I'm like, why do I want to read what he's written? I'm going to be just as put off by it, right? So here we have strange. So we've got a link here. Yes, stop it. We have a citation here in one style and citation here in a different style, followed by a citation back in the original style. Obviously, something was copied and pasted, and the formatting was never fixed. So this was also hastily cobbled together and not really not really proofread for formatting. This footnote has different formatting, a bold and italicized case citation. Oh, hey, look, Bethlehem Steel. That's where I live. That's where I grew up. Let's keep going. Oh, wow. What is going on here with this bolded MM? What? Oh, you got me. That's ugly as heck. Here you have two different fonts here. I'm only 20 pages into this. This is 130 pages, guys. So we're going to start paging quickly. So there's just more and more and more of this. Games, it literally does. It says gamesmanship. Defendants have been gaming the system. Here's a bold and italics in this and normal in the same sentence and paragraph. Plaintiff contends that defendant's actions are/were a willful and deliberate abuse to the judicial process. What is the emphasis? What does the emphasis even mean there? You've got the emphasis on the wrong syllable, as my choir director would say.
I just think that judges want to hear arguments and they want to hear facts. If there's one thing that routinely I've seen judges really bristle at, it's wasting their time. And so it's almost like an insult to hand in something so bad.
Yeah. Like I said, it's also very distracting. I had this discussion with my professors in law school. I used to wear an earring, and I didn't think really one thing or another of my earring. It had sentimental value. It had a meaning behind it, and I not going to tell you what the meaning is because it's very personal. And I liked to wear my earring. I didn't think there was any problem with it, except it's not quite that simple in the year 2010, 2015, 2000, et cetera, 2020. And I asked, would I experience discrimination if I wore my earring in court? And the answer I got back was this. It was a very, very sympathetic, empathetic answer. Yes, you can probably wear your earring in court. It is 2010 at the time, and most judges would probably not have that much of a problem with it. However, you may choose not to wear your earring in court because many judges are very old school and they expect male lawyers to be in a suit and tie and jacket. If you don't have a jacket or you don't have your tie, that's very distracting for the judge, even if we all think that that's stupid. And I do. I think that's pretty stupid that you need to be dressed in a certain attire in order to have rights. But okay, that's how that is, and I'm certainly not going to be able to change that by myself. And the point about the earring then was, what if that's a distraction for the judge? You're not there representing Leonard French. You're there representing your client. What if it distracts from your client's case, the fact that you wore an earring? Even if it shouldn't, even if it's wrong that would happen, what if it makes your client's case more complicated? So I self-censored. Same way we do on YouTube. You saw in there were a couple places where I skipped saying a few words that I knew YouTube would be like counting, like the title word. There's a title and then a number. If I say that too many times, maybe if I just said it once, and there's those discrimination words. If I say those discrimination words too many times, even if I say the discrimination word itself, it might be enough for YouTube to say, okay, we're obviously talking about that situation and we don't monetize those situations. So thank you for joining me. That is our show. You are watching Lawful Masses with me, Leonard French, your favorite copyright attorney. This channel would not be possible without your support. We use patreon.com/LJFrench and sponsors.com/law for our community building and support gathering. This month, the November month of giving, sponsors.com is running a promotion where creators will only be charged a 3% fee instead of the standard 7% fee. So if you are interested in getting started on sponsors, now is the time to go ahead and do that. Visit sponsors.com for more information. I am just a creator on the platform. I am not financially interested or invested in sponsors.com myself. Full disclosure. Thank you to our $50 plus supporters on both platforms: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters scrolling on the LED panel behind me, and all of you will be on the crawls at the end of the videos that drop. Happy fall, everybody. I will be working on some things for you this week, and I look forward to dropping the podcast. I believe the podcast has been finished, and Patreon donors and sponsors supporters, and I believe Twitch subscribers too, will all get access to the super secret link that is the podcast, which will hopefully be dropping later today or sometime this week, early on Monday or something. I'm Leonard French, your favorite copyright attorney. I love you all. Have a great week. I'll see you in the videos. Bye.